Yahoo! Welcome to another scintillating, didactic, and provocative session of commercial law and ethics with your favorite professor, Professor Huckster. How is you today? It is absolutely gorgeous here in Vermtown. We got snow on the ground. It's a balmy 35 degrees out there. Students are running around in their Speedo suits. We've got palm trees blowing in the wind here. Hey, life is good here at what I simply like to refer to as Vermilion on the Missouri. It is absolutely gorgeous here today. Well, we've got one of my favorite topics that we're going to share today. Planning for the future, wills, trusts, and insurance. Topics that you need to be familiar with when we talk about commercial law. So who was King Tut Tut? Come on. Anybody remember him? Well, he was an Egyptian pharaoh, and they found his pyramid tomb, and they took out his mummified sarcophagus, and it's in the Egyptian National Museum. Some years ago, I took a group of students on a Middle East business study tour, and one of the places we visited was the National Museum, where King Tut Tut Kaman now lives. Now, each day I would hand out to my students a quiz, usually a 10-question quiz, to get them to focus on what it was that we were seeing and talking about that day. So when King Tut Tut Kaman's sarcophagus and all of the goodies that were taken out of his tomb were put in this alcove in the museum, and the question that I had on the quiz for the day about Tut Tut Kaman was, well, looking at all of Pharaoh Tut Tut Kaman's wealth, what is your takeaway here? Was he successful in taking it with him? And so that night, as we sat in a circle going over the quiz for the day at our lodgings, I asked that question, from the students. So what was the takeaway from seeing King Tut Tut Kaman and all his gold amulets and whatnot? Everybody was sort of stupefied, looking at me with their usual, Professor Huck, you're having another one of your brain cramps. But I kept boring in. Come on, what's the takeaway here? And nobody seemed to get it. And so I finally had to drag it out of them. Well, look, was he successful in taking his wealth with him to the happy hunting ground? Look at all the wealth that he amassed when he was the pharaoh in Egypt. So what happened to it? Didn't really take it with him, did he? Everything still was left in his tomb, which now is ensconced in the National Museum in Cairo. So what's the reality here? The reality is none of us really take our wealth, or I simply refer to as our stuff, with us to the happy hunting ground, right? It all gets left behind. Aha! Then the question becomes, well, when it gets left behind, who gets it? Aha! And that is the subject of our presentation today. So what is estate planning and its purpose? What is an estate? An estate is one's collective property, and estate planning involves a plan to distribute that property according to the deceased party's wishes. What's the benefit of it? Obviously, it prevents family food fights, right? And it minimizes estate taxes, as we're going to see. So an estate is the collection of all of our property. What is a testator? A testator is the person who makes a will that sets out their estate plans as to how they want their collective property divided up or distributed. The testatrix is a legal term meaning a female will maker, okay? And who's a decedent? I think you got that right. It's the person that croaked is the decedent. So what does it mean to die intestate? It means you died without a will. Oh, baby. So what happens if you die without a will? Well, we have what's called a state statute of intestacy. So if you don't have a will, state law has a system of, all right, who takes your stuff and in what order and in what amount? What is an heir? An heir is someone who is entitled to take under the state intestacy statute because you haven't left a will, but yet because you're a spouse or a child or an issue, as we're going to talk about in a moment, you're entitled by the state statute of intestacy to a certain portion of the deceased estate. What's a devisee? That's a person who takes according to the will, that there is a will that exists. So, if you die without a will, and I'm sure many of you at this point in your life may not have very much stuff, so you haven't prepared a will. But in the unseemly event that you were to die, your stuff, if you will, would be distributed according to the South Dakota state inheritance statute. So another legal term you need to be familiar with is issue. What is issue? Issue is a legal term referring to the blood children of a decedent. Okay? So it excludes adopted children. And so when the term issue, if you use the term in a will that I leave to my issue in equal amounts the following, property. Well, you're referring to children by blood. But if you have adopted children, you better name them by name if you want them to take under your will. Probate is the process by which property of the deceased is accounted for, filed with the probate court, and to include the will, and a proposal as to how it's going to be distributed. Who is an executor versus an executrix? The executor is the male person who is named in the will as the party that the deceased is appointing to distribute the estate. Someone's got to be in charge, right? An executrix is the female person who, under a will, is responsible for collecting and distributing the estate in accordance with the will. But who's an administrator or an administratrix? If we don't have a will, and you're dying intestate, then the court will appoint an administrator to distribute your property according to the state intestacy statute. The administratrix is the female party that would perform the same function when there is no will. Who is a grantor? A grantor is a trust creator. So it's very common for parents to create a trust upon their death to take care of their minor children. A settler is the same term. So those terms are used interchangeably. So let's talk about what a will does. So we're back to King Tut Tut Come On. So what happened to his stuff? Well, I don't think King Tut Tut Come On had a very long will. I think it just simply said, put all my stuff in my tomb so I can take it with me to the happy hunting ground. Well, okay, that's fine. But a will is a direction of how you want your estate to be distributed. A guardian is a third party who is usually named in a will. If you have children, you will name a third party quite often to serve as a guardian of the children. It could be appointment of someone to take care of a person who has become disabled. Like, for example, I have a mother-in-law that my wife and I care for. She is disabled. And, when her husband died, he predeceased her, he left instructions appointing my wife the guardian to care for her. Not unusual. So who do they guard? Certainly the person, but there may be a separate party, another guardian, who's appointed to take care of the assets of the person who is being guarded, if you will. Or they can be one and the same person, which is not unusual. We talked about the testator and the testatrix, the male or the female, who makes a will appoint a personal representative to carry out the will's intentions, and that is the executor or the executrix. Now, it's important to understand this function. It is a legal function that they perform, and they do have to file the will and their proposed distribution, their plan to distribute the assets with the local county probate court. Now, by statute, testators and testatrix are often entitled up to 5% of the estate. But it's also common that testators and testatrix will, may require their personal representative to serve without a fee. Otherwise, the court will have to appoint one. Lawyers who act as executors or executrix or administrators or administratrix are going to be entitled to charge by the hour for their legal services, or they may elect to take 5% of the value of the estate. Now, if you're serving it as an executor or an executrix or an administrator or administratrix, you're going to need to hire a lawyer to help probate estate of any size, of any good size. And so one of the things, as with any service, you're going to want to negotiate the fee. So if the estate is worth $1 million or more, geez, 5% would be, like $50,000 going to the potential, testator, testatrix, or, attorney who's handling the estate. You may want to negotiate that. What are the legal requirements for making a will? Actually, you have to have the minimum age of 18, so it's just like making a contract. Does the person possess the legal capacity to understand the nature of the responsibilities they are exercising? And so, as a matter of law, people over the 18 are considered to possess that capacity. Sound mind, what does that mean? Same issue as in contracts. Is the person compos mentis? Are they mentally, competent? And are they acting without undue influence? So it's not unheard of, and we'll take a look at a case here in just a moment, that cases arise of individuals in rest homes or in hospitals who all of a sudden want to leave all of their estate, not to their children, but instead to their tending nurse or caregiver. Well, let's take a look at a case that addresses this type of situation, because it is not uncommon and does pop up from time to time. So we're going to look at the estate of Ulrich. So we got Ulrich, who had a surviving brother, and his brother had two daughters, which were Ulrich's nieces. Now, when he was 68, he made a will that left his estate to his nieces and their but he later met a lovely lady by the name of Susan Sorensen, who was a customer at Ulrich's farm. 10 years later, Ulrich suddenly broke off communication with his brother and closest friends because he thought they had stolen items from his home while he was in the hospital. Yet there was no evidence they had ever taken anything. So he's probably suffering a little dementia here, right? Not unusual for an elderly person. So Ulrich began to rely on this young lady, Miss Sorensen, to help him with his household chores, personal grooming, and such. And he began bringing her and treating her as a daughter to family events. So I'll leave that to your imagination, how that probably went over the family. Well, when poor Ulrich got to be like age 80, he decided, I need to draft a power of attorney that gives Sorensen the authority over his affairs. And he also drafted a will that left left everything to her. Now, he told his lawyer that Sorensen wouldn't accept a power of attorney unless it came with the power to control all his money. He believed in good faith that she would take care of him and keep him out of a nursing home. Didn't want to go there. I don't want to go there either. Now, when the lawyer refused to draft the documents, Sorensen recommended another law firm. So, while Sorensen drove him to the new law firm's legal appointment, she didn't attend the meeting. But based on the unusual nature of the request, that he's changing his will and creating a new one, leaving everything to Ms. Sorensen, the lawyer asked two other lawyers to sit in and evaluate Ulrich's mental competence and the possibility of any undue influence. Later, all three lawyers found that Ulrich was very strong-willed, but he was mentally competent. So 3 years later, Ulrich went into a nursing home. Sorensen visited him, took him out on excursions, and bought him whatever he needed. During the last 5 years of Ulrich's life, Sorensen wrote herself $256,000 in checks from Ulrich's accounts. She said they were gifts from Ulrich. So you're probably wondering, do we have a issue here of potential influence? So after Ulrich died, one of his nieces sued, alleging that Ulrich's will, the one that the latest one he had executed, was invalid because he was subject to undue influence. Now, Sorensen moved for summary judgment, that is a dismissal of the complaint by the niece, which was granted, and so she appealed. And so on appeal, the court's looking at this, looking at the specific issue that when Ulrich changed his will, was he unduly influenced? The question, right? So what's the law here? Absent evidence of undue influence, unusual bequests or gifts to beneficiaries are not unlawful. So the burden is on the complainant to prove that Ulrich was unduly influenced by Sorensen. So what did the evidence presented before the court disclose? There was no evidence that Sorensen told Ulrich to change his will or make the power of attorney. Remember the three attorneys that were present that said, hey, he seemed to be strong-willed, but hey, he nevertheless, knew what he was doing. So the three lawyers testified he was not confused or persuadable. In fact, they thought he was pretty hard-headed. And so they affirmed the trial court's dismissal of the complaint. So you're going to have to show with some means of evidence that there was undue influence, and that is a hard thing to do. So hence, if you have relatives that you put into senior homes or care centers, you better watch after them, visit them frequently, and if they want to start changing wills, you better, have what's called a competency determination made. So that brings us up to a holographic will. Gee whiz, Professor Huck, what is a holographic will? I've never heard that legal term before. Well, would you believe a holographic will is a handwritten will? Handwritten will by the testator or testatrix. So what are South Dakota's legal requirements, which are similar to most other states? Well, the holographic will has to be in writing, right? The testator or testatrix has to sign it or direct someone else to do it if they cannot sign. And in South Dakota, you don't need witnesses to sign authenticating the testator's signature because you normally have a notary who is a public official, obviously having no interest in the case, who will come and notarize the signature of the holographic will maker, the testator or testatrix. Now, it's important to know, where do you find a public notary? All banks have notaries, and if you've got a bank account, you almost always can get free notary services. Clearly, if you need the notary to go to the care center or a hospital To do a notarization, there may be a very small fee involved in that. But they have a seal and a stamp that they put on the handwritten holographic will that indicates that they were present, and as an official notary for the state of South Dakota, they witnessed the signature of the testator or testatrix. Clearly, beneficiaries should never act as witnesses for, to me, fairly obvious reasons. So what's a non-cubitive will? Non-cubitive will. What do you think? Well, it's an oral will. It's an oral will. So where do we see these oral wills come into play? Well, when we have a testator or testatrix who knows they're dying, and they've got two witnesses that are present to certify that the person knows that they're making a will and orally giving them instructions as to what he or she wants done. Obviously, the two witnesses better not be beneficiaries, or you're going to have perhaps a conflict of interest here. The witnesses, of course, need to know that they are listening to the testator's last will, oral testament. Now, South Dakota is not a community property state, but there are 9 states that are. Most of them are in the West. California, Arizona, Oregon, Washington, Idaho are community property states, as well as Texas and Florida. So in community property states, a surviving spouse can override the will and is automatically entitled to 1/2 of all property acquired during the marriage. But bear in mind, South Dakota is not a community property state. So even though a spouse contributed nothing to the accrual of property, they, in a community property state, are entitled to 1/2 of it. So how does South Dakota handle these types of situations? Well, in South Dakota and other non-community property states, a spouse is entitled to claim a percentage of the estate according to the state inheritance statute. So in South Dakota, if you've been married less than 2 years, the spouse is entitled to automatically 3% of the estate. If you've been married 10 years, they're entitled to 30%. And as you might imagine, as the longevity of marriage increases, they're entitled to more. Children are in these states in South Dakota are entitled to take a share according to the state inheritance statute too, if the will hasn't provided for them. We'll talk about that. Now, what is a pretermitted child? A pretermitted child, I love that term, pretermitted. That's a nice term you can use at a cocktail party. Gee, have you got any pretermitted children, Louise? It is a legal presumption that a child has been omitted or forgotten by accident in a will. So in other words, can a testator or testatrix disinherit a child by simply not mentioning them in a will? No, no, no. They would become, by state statute, a pretermitted child and be entitled to receive something. So if you want to disinherit, that is, not leave anything to speak of to a child by issue or adopted child, how do you do that? Real simple. Leave them $1. I leave to my son, Gurgle Fumblebee, $1. So clearly you haven't forgotten Gurgle, right? You haven't. You left him $1. And that's the way you can effectively disinherit children. So let's talk about the Traylor estate. So in Trehor's situation here, he left a piece of land to his daughter and another to his son, with the remainder of his estate to be divided equally between his 3 children if his wife predeceased him. After his daughter Evelyn died, Trehor made a second will. To aid in its drafting by his lawyer, he furnished the lawyer a copy of his first will with Evelyn's name crossed out. Why? Because she had died, right? The new will left everything to his 2 other children divided equally, with nothing to Evelyn's husband or Evelyn's children. Now, under the state law of New Hampshire, all issue, to include children and grandchildren, qualify as pretermitted heirs. So if you don't name them in the will, they're going to be presumed to have been forgotten, and they're still going to be entitled just like designated children in the estate. The attorney who served as the executor refused to pay Evelyn's children and husband anything, so they brought suit under the pretermitted statute. And the legal question presented was, are Evelyn's children entitled to a share of Josiah's, the decedent's, estate? What's our rule of law? The law assumes that if the testator doesn't leave anything or mention his issue, then the assumption would be that he's forgotten them, and then the state statute kicks in, and they're entitled to something according to the statute. So in this case, the executor, person responsible for carrying out the estate, argues that when the first and second will are read together, it is clear the testator considered her. The new will, however, stands on its own. You can't merge the former will and the present will together to try and make deductions as to the testator's intent. The indirect references would not satisfy the statute for the purpose of disinheriting Evelyn's children. Her children are pretermitted heirs, despite a statutory portion, entitled to a statutory portion of the estate. So more legal terms, more legal terms. Oh, Professor Huck, you are drowning me in all of these legal terms. I just don't know how I'm going to handle all this. Well, do your best. What is per stirpes versus per capita distributions under a will? Per stirpe simply means that each branch of the family or each child receives the same amount. So assume for the moment you have 3 children, and you are leaving 1/3 of your estate to each child. But one of your 3 children is dead. That deceased child has 2 children, and so that would be a branch of the family that would receive the decedent's 1/3. Okay? That's what per stirpes means. Each branch of the family or each child receives the same amount. Now, per capita, when we use the term a per capita distribution in a will, means each heir receives exactly each heir. So each person entitled to take under the will receives the exact same amount. And if a child predeceases the testator, then the share flows through to the deceased child's children, as in the example I just gave you. What about digital assets? Anybody out there with Bitcoin? So who's entitled to a deceased online property? See the online terms of service to determine that. What's a codicil and how is it executed? A codicil is simply an amendment to a will. So you may have a heir who predeceases you. Rather than rewrite your entire will, you may just simply decide to amend it with a provision as to who you want the deceased heir's portion to go to. Simply an amendment. That's all a codicil is. But it has to be executed in the same way as a regular will, with a notarized signature and so forth. So what does it mean to die intestate, like the Rocky Mountain High singer John Denver? Well, if you don't have any heirs, what happens to your property? As in King Tut Tut Kaman's case. So he didn't have any heirs. So where'd all his property go? It was escheated. What does escheat means? It means it goes to the state. And so the state of Egypt got all of Tut Tut Kaman's property, which they now have ensconced in the National Museum in Cairo. So that, of course, is important why you want to have a will. So even though you may not have any heirs, okay, if you want your property to go to the Girl Scouts or to some other charity, you really need to articulate that. What's the power of attorney? All of you have been subject to powers of attorney. By that I mean you've had parents who have created a power of attorney that authorizes another party to act on your behalf. Now, let's distinguish general versus special powers of attorney. Clearly, you know what an agency is, right? It creates an agency. It authorizes a party to act on your behalf. A general power of attorney is one that authorizes a person to literally conduct and take any action that the issuer is making. Whereas a special power of attorney limits the power that the agent can exercise. So, for example, you may issue a special power of attorney, as people do, to care for children when they go to scout camp and other types of athletic activities, or to register your car, or to pay your taxes, or something very specific in nature. What is a durable power of attorney? That's a power of attorney that survives the disability of the maker. What's a springing power of attorney? Those come into effect when some event occurs. So, for example, as in my mother-in-law's case, she issued a power of attorney. Now she's suffering from dementia. It comes into effect and operates when she is no longer able to take care of her affairs, which has now been triggered by her dementia. How does a will affect joint property, insurance, designated beneficiaries, retirement beneficiaries? All these things cannot be affected, that is, cannot be changed by a will. So let's get into this a little deeper. Organ gifts. How do you make an organ gift? So in South Dakota, we have little notations on our driver's license that indicate whether or not we're interested in having our body parts given to others, if you will. And so how does this work? Clearly you can do it by will, but the reality of most wills is people don't find them or read them until several days after the funeral. So the smart thing to do is to tell your executors or executrixes if you want your bodily parts to be used for science or to go to another party. What are living wills? Have you heard that term, a living will? It is essentially a health proxy, authorizing other people to make medical decisions on your behalf. Physician-assisted suicide exists in Oregon, Washington, Montana, and a few states. Now, this is not an easy process, so anybody that thinks, hey, when a relative decides, well, I've had it taken care of my dementia parents, it's not an easy thing to do. There has to be, obviously, an attending physician. There has to be a committee of physicians who are neutral, have to try and make a medical determination. Is this the person's compos mentis decision? And does it make sense under the circumstances, and so forth and so on. So this is not something that happens quickly or easily. In fact, it's very complicated. I don't think it's actually going to spread too quickly. So what is a trust? You all have heard of trusts before. These separate what is simply referred to as the legal ownership and the beneficial ownership. So why is that important? Well, because it involves a trustee and someone who benefits from the trust that has been created, and then involves trust property. So let's take, for example, the Rockefeller Trust or the Kennedy Trust. Those are examples of trusts that are out there. What are the advantages of a trust? Well, the grantor can control assets after death, right? And that they put assets into a trust. Trustees care for assets, for example, while children mature, can also save on taxes. Trust documents are private, while wills are required to be filed and made public. Trusts skip the probate process. Domestic asset protection trusts can protect against creditors. You can't get at trust. Creditors to estates can't pierce trust protections. Major detraction, of course, are the costs of expensing, that is, managing a trust. Frequently, at least a 1% management fee. Banks have trust departments that execute trusts, but of course, they charge a hefty fee. What are gifts that are made inter vivos? Those, so for example, would be setting up a trust during one's life, as opposed to setting it up after you die, which would be called a testamentary trust. Fiduciary duties are exercised by a trustee. We all have talked about the F word in the past. What is a fiduciary? One who has a legal duty of utmost trust. So banks and other parties have that duty and obligation. A duty of loyalty, duty of care, and so forth. Have you ever heard the term decanting a trust? Well, that's pouring the assets of one trust into another. For example, having a family trust distributing assets into a beneficiary trust. The Kennedy Trust is probably a really good example of that. When do trusts terminate? Trusts terminate when we have the rule against perpetuities kicking in. What's the rule against perpetuities? Law students love this. The rule against perpetuities prohibits indefinite trusts, requires that they terminate at least 21 years after the death of a named beneficiary. Can you get around this rule of perpetuities? You can, by creating a foundation, which certainly the Rockefellers have. So clearly trust can terminate on a date that's been designated by a grantor who set up the trust. You see that with children. When children reach the age of 25, 30, or whatever, then they can now possess the trust assets. If it's a revocable trust, when the grantor revokes it, it can be terminated. Or if it's irrevocable, then if you have an agreement by the grantor and the beneficiaries, or when the purpose of the trust is fulfilled, you can terminate it. Now note there are 25 states that permit what are called perpetual or dynasty trusts. South Dakota permits them too. So you see them, for example, with family farms, that you want to keep it in the family. Let's talk about insurance. So who's an insured and who's an insurer? An insured is the party who's insured, and the insurer, right, is the company who is providing the insurance for the insured. The beneficiary quite often is a different party if it's a life insurance, for example. Now, fundamentally, insurance is a contract subject, right? Which is going to be subject to the defenses of fraud, undue influence, duress, just like contracts, because insurance is a contract. What's an insurance binder? It is a temporary insurance coverage until final approval is normally given by a insurance company's home office. What's an insurable interest? The owner has to have a legal interest in the subject matter of the policy. So, for example, you can't take out a life insurance policy on your professor. Why can't you do that? Because you don't have an insurable interest in me. My spouse and certainly my grandchildren do. Let's talk about loss limitations in insurance policies. You all have auto insurance, and you all have what are called policy face limits. So let's say you have one with a $100,000 limit, but yet there's a $200,000 judgment found against you. Well, your policy will protect you up to $100,000. They will pay, but you're stuck for the remainder, $100,000. Who pays legal representation fees in automobile accidents and insurance types of contracts? It is the insurer, that is the company, that hires the attorneys and pays the attorneys. In partnerships, professional corporations and such, Why would you want to have an insurance policy on the lives of the partners or principal owners? Well, because when one of them dies, you obviously are going to have heirs. They're going to be interested in being paid the interest of that partner's interest. And of course, you're not going to have that type of cash laying around. And so it's very common for partnerships, PCs, and whatnot to have life insurance on all of their members that make the life insurance payable to the partnership or professional corporation. So now that you have the cash with which to make that payment. The Banta properties, I think, is a good example. I'm not going to go into detail, but this is a case where we had family-owned businesses, several of them, and we had a claim made by one property against another. But the reality was the one of the properties, the only insurable interest they had was 4% of the gross income in exchange for the property's management services. So you have to have an insurable interest in order to be able to make a claim. How about an insurer who refuses to pay a claim where the insured made a material misstatement in their application? So, for example, I have a deceased grandmother who I recall had put on her driver's license and in her insurance application that she was only 65 years of age when in fact she was 80. That's a material misstatement and would act as a basis for an insurance company not paying because you did not provide them accurate information. Unreasonable delays in payment certainly can damage claimants, create duress and things of that nature. And so claims such as, sue us, we'll keep you in court for 16 years to try and keep or try and get claimants to take less money, that obviously can be problematic. The Goodson versus American Standard Insurance case, take a look at this case. That's the situation here where we had an insurance company that was acting in bad faith. And so non-economic losses such as emotional distress, pain and suffering, fear and anxiety, impairment of the quality of life are all claims that can be made against an insurance company that does not pay in a timely manner. What is casualty insurance? It's the same as property insurance. So, for example, casualty insurance would involve your automobile, right? And may involve other types of property, homeowners insurance, for example. What is term insurance versus whole life insurance? Term insurance, you have a flat fee that you pay for your term insurance, whereas whole life, both obviously involve face amounts on the policy, but a whole life policy really gives you a return of the increase in the value of the amount of money that you put into the policy. You actually need to think about insurance. Insurance is merely a service. It is not a good investment. And so you can get a lot more coverage, hundreds of thousands of dollars worth of coverage for the same price that you would end up with only getting, a much smaller amount of coverage with a whole life policy. So term is much more financially popular. What's an annuity as opposed to a life insurance contract? Annuities, in exchange for, let's say you buy a $500,000 annuity, which means you put $500,000 in, and then you get a payment in accordance with whatever your annuity contract is for the period of your life. Now, what I recommend you be careful about annuities is you don't want an annuity where the company keeps the principal when you die. You want to have an annuity contract whereby the principal goes to your heirs. So there are different ones, so check them out very carefully. Health insurance? Whoa, let's talk about health insurance. So what does a traditional health insurance contract pay for? Services, right? Services regardless of outcome. So for example, 60%, how about this? 60% of Medicare costs are paid during a patient's last year of life. Did you know that? 60% of Medicare costs are paid during a patient's last year of life. So what's a managed care plan? Well, while healthcare delivery services try and limit choices because they try and get you into health maintenance organizations that offer services. Kaiser Permanente, Sanford, Avera are examples of managed healthcare plans. Now, under the Affordable Health Care Act, better known as Obamacare, that changed some of the rules here, because while you had to pay for these health care managed plans, regardless of the outcomes, you still had to pay. Under Obamacare, no. Medical providers are paid based on outcomes, which meant if you came into the hospital to be treated for X and kept having to come back to be treated for X, eventually Obamacare would not pay for X because, hey, you didn't fix the problem when you were reasonably supposed to. What is disability insurance versus liability insurance? Workman's comp is an example of disability insurance that provides 60 to 70% of income replacement. In business, hey, come on, accidents happen. So why should a business have business liability insurance? Because you have accidents, you have professional malpractice, you have employment disputes, legal expenses. The insurance company picks up your legal expenses here. And when there's a claim to be paid, up to the face amount of the policy. Auto insurance. You all have auto insurance? Have you noticed there's a difference between collision and comprehensive? Collision only covers when somebody hits you. Comprehensive insurance involves, in addition, theft, fire, and weather. So what is liability? Liability insurance versus personal injury. Liability insurance covers all expenses up to the face value of the policy, where a personal injury insurance only covers physical injuries, not property injuries. So clearly, comprehensive insurance is the most expensive, but also the most comprehensive. And then, of course, you have uninsured motorist coverage, which most people have today because we have essentially a no-fault statute, not just in South Dakota, but many states that simply say that in most cases, each party pays their own damages regardless of who is at fault for the accident. Well, that's a lot, I realize, but I wanted to cover with you today. If you have any questions, as always, I recommend you give me an email. Let me know what's going on, and I'll get back with you forthwith. Have a good week. Bye-bye, guys.